So we are going to restart our reading of the Philosophy of Right. We're going to take a look at all of these paragraphs, paragraph 71 to 81, beginning with the transition of property to contract and then ending with the transition of contract to injustice. So what I want you to do is to read carefully paragraph 71, just pause the video, read it for yourself in an English translation or in German if you're capable to do so, and then we're going to take a look at my summary of that paragraph. Okay, so the first statement summarizing paragraph 71 goes like this. Property is something external for someone other than the owner. Aber als Dasein des Willens ist es als für anderes nur für den Willen einer anderen Person. So as the existence of the will, the objective existence of the will, a property is for someone else, that is only for the will of someone else. Now we know already that property implies a negative relation between the will of the owner and the will of all others that are excluded from his property, from my property if I'm the owner. So property is something external for someone other than the owner precisely because he is excluded from that property. Now Hegel goes on to say, diese Beziehung von Willen auf Willen ist der eigentümliche und wahrhafte Boden, in welchem die Freiheit Dasein hat. So this relationship between one will and another will, that is the true basis in which freedom acquires objective existence. So it's no longer about property as the connection between my will and something external, but it is basically about a positive relationship between my will and the will of others. And as soon as we are talking about that, the positive relationship of the will of the owner and the will of all others, then we're talking about contract. There is an agreement between those wills that is the basis of the contract. Now we have to understand this is not something new. The idea of contract is not something new that is now added on to the previous discussion of property. The whole section of contract is merely the explicitation of what is already contained in the concept of property. The idea of property summons up the idea of contract. Now, this is true only in a philosophical analysis. Of course, it is not true in the sense that it refers to the historic development, that we first only had property and then we had contract, etc. That is not the idea, and it's certainly not important for positive law. That is not the way that we talk about contract in a legal setting. What Hegel tries to do in all of these, with all of these concepts, is to understand the meaning of property and the meaning of contract from the point of view of liberty realizing itself. That is the subject matter of the philosophy of right. How does human freedom realize itself? How does it give itself an objective reality? Now, by doing so, he is not only trying to establish that contract and property express this freedom to some degree, but also that property and contract are limitations or have limitations with regard to the freedom that is expressed in it. As means to realize freedom, both property and contract have their limits. Now, in property, it's all about a relationship between the human will and a thing. In contract, we now see that this relationship that we have in property has a presupposition. Contract is the presupposition of property. Within property immediately we see this negative relationship between one will and the other, but in contract, this presupposition of this relationship between diverse wills is now expressed more explicitly. To be a lawful owner implies the recognition by others, and the freedom that we have in an external thing is only real when recognized by others, so only when it is grounded in a common will. Now, the way that this common will that grounds the possibility of property, the way that this common will is now expressed immediately is in a contract where this commonality of the will is actually the contents of the thing, contents of the contract. The contract is an exchange of things on the basis of an agreement, and therefore it is the actualization of a common will. It's the objective form that this common will can take. So we see here very nicely how freedom is realized. Freedom is realized by having two wills concerning a thing of property, come to an agreement and exchange that property, and in that process becoming and staying the owner in terms of the value and becoming owner in terms of the thing acquired. Now, the thing in which I put my will is something external. It's not a sein für sich, a being for itself. It's a sign for others, a sein für anderes, and that is what I'm trying to express here in the summary. Basically, property is about the relation to external things. But this sein für anderes is not just a point of singularity, it's also the objectivation of a singular will. So that is something very important. Sein für anderes is not just a characteristic of the thing that we're talking about. Sein für anderes, being for another, is also a characteristic of my will in its relationship to other wills. So the whole idea of property implies structurally, it's something internal to the concept of property, the relationship between singular wills, and in contract, this relation of singular wills now becomes explicit, where it at first only was implicit. In that sense, the contract is a new form of right. It's a specific way of existence of right, not just embodied in an external thing, but embodied in a common will. That's the new thing. In contract, the relationship of wills is not embodied in an external thing, but also in a common will. In a contract, I acquire property by disposing of property or disowning property, and on the basis of that agreement with other owners, I acquire a new property. So I am an owner because we want it to be like that. Let's take a look at this sentence from paragraph 71. It is obvious that we can give our property away, trade it in for something else, or sell it. All of these actions imply the negation of my property and the acquisition of that same property by someone else. So it's a transition of the thing from one sphere of ownership to the other sphere of ownership. This is called contract. It presupposes the recognition of legal personality and properties. So the recognition that someone else can be an owner, is a person in a legal sense, and that he can have properties, that things can be not just in his possession, but rightfully in his possession, and therefore they are Eigentümer in Eigentum, I must say, in German. Contract means that there is a common will that is expressed in the contract concerning an exchange of property. Now, what is what is conceptually going on in this idea of the contract? Let's take a look at the summary of paragraph 72, where Hegel discusses what happens in the exchange of property. Now, any contract produces, it posits, it's a position that is taken up by the common will, produces a property that is no longer just a thing, but also characterized by the action of the other will. This means that the thing that we are exchanging, or buying or selling or whatever, is not just this thing of perception, not just this thing with its external qualities, but now it is characterized by something in an ideal form. It has an ideal, and not a real, but an ideal characteristic, i.e. that it is the object of the action of the other will. It is posited that this something, this thing that we're talking about in the contract, is actually desired by another person. This leads to an exchange of property that is a matter of the interaction between free wills, and there we have a basic and immediate expression of our social being. But it contains actually the contradiction that I am both the owner that excludes the will of others, while being recognized as such, and at the same time cease to be that owner of that particular item, that particular property, in the exchange that we now have of property. We're swapping, or we're buying or selling or lending or whatever, all on the basis of a common will. So there's this contradiction. In as far as I'm the owner within the contract, I exclude others, but in as far as I'm doing the exchange, which is based upon the fact that I can change my will and I can divest myself of a property, I can negate the property, no longer want it. There now comes into being this mediated characteristic of a thing that is both my property and desired by someone else, and is then discussed in the agreement that it will be exchanged for something else, or that it leave my property and become someone else's property. Now, let's talk about this common will for a while by looking at this paragraph 73. How do free wills interact conceptually with each other in the exchange of property? But let me first say something else. I think I said it before in another video. The concept of property within Hegel's philosophy of right is a category of right. That is to say, it's a category that expresses the urge, this desire, this tendency of freedom to want to objectify itself. It's not an economic category. It may be true that there are only parties to a contract because they have economic motives. They want to provide for themselves. It may be true that there are particular interests that are involved on either side of the contract. It may be true that this common will is only sought after because of these economic motives. But that is not the basic thing within the philosophy of right. There's something much more fundamental at work here, and that is what Hegel might call the interest of reason. Whatever our desires may be, whether or not the individual person is aware of that, the contract realizes something universal. In the contract, the parties to the contract recognize each other as owners, as being free persons having this very important aspect or dimension of being for themselves. Now, Psychology may intervene here and talk about the way that we desire things. Economy can intervene here and talk about the necessities of our acquisition of property. But both of these, both psychology and economy, actually are merely the partial perspectives and the much more fundamental dynamics of this objectivation, realization of liberty is on the basis of all of that. Even if it's not my intention whenever I enter into a contract to recognize someone else as a free being, that is actually what I'm doing. The reality of the contract is a recognition of the personality of the other, even though that is of course not the main object of the contract. Now, the contract is only a limited realization of this desire to realize itself. It's not universal yet. It's not the universality of our social life as a whole. It's only commonality, and that is expressed already in paragraph 71. Now let's move on and go through the summary of all of these paragraphs after these introductory statements. Now, this is very important. I'm unable to get rid of my property simply by discarding it or by destroying it. To get rid of a property as such, I must also objectify my current decision to disown something. A very important element. When I leave something behind, I'm still the owner. When I forget that I own something, I'm still the owner. Recognized as such by others. So to get rid of a property requires an action on my part. The same manner that to acquire a property requires an action on my part. So when I want to, on the basis of my free and arbitrary will, when I want to get rid of something, I must objectify this volition of my decision to get rid of it, to entäußern it, as it is called in German. And in that action, my will is objectified. That's important because that's what freedom is all about, to objectify itself, to make it a reality that exists both for me and for someone else. Now, I added to this, since no thing can have no owner. That is not completely true when I abandon something and someone else takes it into his or her possession. That might give a basis for a new ownership. When I leave something behind. But that's a part of positive law. That's how things are organized within a society. In a philosophical sense, my ownership remains until I die. So even if I leave things behind, I'm still responsible for them, which of course is also recognized by law, by positive law. And so it really needs an action on my part to get rid of a property. What I want is that someone else can now take my property into his or her possession rightfully, in a legally binding manner, in a manner that is recognized by others, by society, by the rules of my society. My will to negate my property, I've called that disowning, is at the same time the will of someone else to acquire the property and become its owner. So I have here this thing, and you want it, and I want to get rid of it, but now we need to do something to signify the fact, to make it objective, that I'm no longer the owner of the thing, and you have become the owner of the thing. I'm disowning, and you're acquiring. When I objectify my will as owner, that is what is therefore needed. I have to objectify my will as owner to relinquish the thing. It becomes identical to the will to acquire that of someone else. So you and me are interacting. I'm saying I want to get rid of this. You saying that you're glad that you can now have it. And in that speech, in that discussion we have, or in that contract we write down, my will to disown is objectified and your will to acquire is objectified. It now becomes a reality for a third party. and your will becomes reality to me. That's more than just a statement of intent or a speech or some kind of personal communication. Something really changed in the world. As soon as we have that agreement, as soon as we speak to each other about what we're going to do, there is something happening in the world. Now, the first thing to notice is that there is an identity of these different acts of volition. They are different with regard to the same object. You want to acquire, I want to get rid of it. Those are different acts of volition, and yet they are identical because there is agreement between the wills, and there is the agreement is about this particular thing. The same thing in your act of acquisition, and the same thing in my act of relinquishing, getting rid of it. However, in this identity, it is at the same time contained that the one act of volition, to dispense with the property, to disown it, and the other act of volition, to acquire that property, are not identical but contradictory. You are acquiring property, so you become owner, and I am giving it away, so I stop being owner. In that sense, they are contradictory. So how can that contradiction be resolved? Now pause the video and take a look at paragraph 74 now, and then we'll dive into paragraph 74. Okay, glad you're back. The summary says the mutual conditionality contained in the exchange of properties is the social character of property. So what is really expressive of our social relationships, our intersubjectivity in the exchange of properties, is this mutual condition. I can only give away what you want to accept, and you can only accept what I want to give away. There is a mutual conditionality. Only on the basis of my decision to give can you acquire. Only on the basis of your decision to acquire can I give it to you. That is important, but it's just a social character of property. Two wills are identical. We want the same thing. I want you to acquire, you want me to give, etc. Two wills are identical and at the same time absolutely different. Absolutely different. Because the act to disown and the act to acquire are totally opposite. I'm no longer the owner, you become the owner. That's different. I can only acquire something when someone else gives up his property. We talked about that before. I can only give up my property when someone else recognizes that and takes the thing into his possession. The social reality of property is apparent in this dynamic process of giving and taking, selling and buying, exchanging one thing for another. Okay, so take a break and read paragraph 75. So now we're going to talk about the conceptual elements of contract. Now, first of all, that is alpha, the Greek letter alpha in paragraph 75. Every contract has the free will as its presupposition, i.e. the arbitrary will that allows me to strive to acquire anything I want. The willkür is what is meant here. That's the first element that we have here. So remember that in property and contract, we are talking about the free will on the level of its immediate form, its immediacy, and that is the arbitrary will that can focus on something and can then retract itself, can turn to something else. Now, that position is still present. Of course, we have discovered that this free arbitrary will becomes objective to some degree in property, and now it becomes objective in the relationship to other wills, to other forms of arbitrary will in contract, but it's still this arbitrary free will that we are talking about. We have not yet reached this level of the universal will. Now in every contract, that's the second element, the beta element in the paragraph, In every contract there is an identity of the will that is posited by the persons involved in. So this arbitrary will posits, it agrees upon, and it expresses an identity of the will. We are in agreement. And therefore there is a common will, not a universal will in and for itself, something that is necessary for freedom to realize itself. It has this character of we can do it, we can discard it, we can do it at a later time, we can change it, whatever. It's based upon an agreement that we reach or don't reach, but it's totally dependent upon our free, arbitrary wills. This implies that the contract has a social character. Sure, there is an element of intersubjectivity. There is you and me, and there is a third party that has to recognize what we have agreed upon. There is a society as a whole that has to recognize and legitimize the way that we do it. We're not just absolutely free in whatever we do, but all of that is still implied. The contract has a social character, therefore, without defining society. It's unable to define society as such. And that is interesting because many within the natural law tradition, of course, have used the idea of contract to try and understand society as a whole. The object of any contract is just this individual and external thing, and that is because we had to start from arbitrary will. So as long as we talk about external things that we can possess in exchange, that we can have contracts about, we are also talking about its about the correlation between that and the free arbitrary will. They are connected to each other. Arbitrary will has external things that it is looking for and is directed to. This fact defines the limitations of the concept of contract. As I said before, Hegel in his Philosophy of Right is also very much interested in the limitations of these categories with regard to the basic principle of this self-realization of freedom. This fact defines the limitations of the concept of contract. It's arbitrary wills combining themselves into an agreement, into a common will with regard to an external thing. That's all that we're talking about. Of course, that is an element of the self-realization of freedom, but it's certainly unable to express the whole reality of that freedom. It's not applicable to higher forms of social ethics. And now in the Anmerkung, the remark by Hegel himself in paragraph 75, we find the application of that. As a consequence, we cannot understand something like marriage as a contract. Why not? There seems to be a common will involved. Both parties agree, they have an agreement, and there is an execution of that agreement, the marriage being executed, performed, however you like to call that. So it seems to be something like a contract. Immanuel Kant actually thought that it was. It was an agreement with regard to an external thing, and the external thing were the genitals. In Kant's definition, can you believe it? In Kant's definition, a marriage is a contract containing an agreement for the mutual use of the genitals. Now, the unmarried Kant may think that he had a point here, but of course that is quite nonsensical. But it seems to have been a consequence of his idea that in the area of right, of law, we can only talk about external things and arbitrary wills. So for him, the whole nature of marriage being a legal contract could not be expressed within the sphere of that legal contract, but of course had to be expressed in the sphere of morality. Now, Hegel defines his philosophy of right not just as the philosophical analysis of legal forms, so he will never try and define marriage like this. He thinks it's overstepping the boundaries of Abstract Right to talk about marriage like that. The common will in a marriage is not focused on a singular and external thing, no matter how Immanuel Kant looked at human sexuality. That is not the case, Hegel says. The same goes for the idea that the state is basically a contract. Where did we learn that the state is a contract? Is it not Jean-Jacques Rousseau? Whether we look at the state as a contract of everyone with everyone, so that is the common will of Rousseau, or as a contract between everyone with a king. If I remember correctly, that is the idea that John Locke in his Leviathan has proposed. Both marriage and the state must be understood as something other than a mere commonality of arbitrary wills concerning external things. The conceptual determinations of contracts should not be applied to social morality and the state. Okay, the next video will continue to talk about paragraph 76. For now, goodbye. Try and reread all of this, paragraph 71 to 75. And take a look later at the next video where we start reading in paragraph 76. So welcome back. This is the second part of my discussion of the category of contract in the philosophy of right. Before we start reading in paragraph 76, and just a couple of remarks about the whole of contract and the meaning of contract. Now, in a contract, two parties make a deal. They have an agreement, and that agreement concerns one or other concrete thing, a thing that we can perceive, an external thing. And this agreement of will is therefore relative. It's limited to this or that we are talking about, that we want to exchange or sell or whatever. Now, the entirety of the will that is involved is not expressed in this agreement and this mediation that we have here between two particular wills. We have a particularity, we have certain interests, we have a drive that exists besides the contract, besides the agreement that we make. So we don't have a concrete universal, we just have a commonality. That was the lesson in paragraph 71. True universality is a full unity of the universal and the particular. But besides this separate and relative universal of the common will, we also have the particularity of the personalities involved, the parties of the contract. So we abstract from all of that. We abstract from the particularity of the persons. The commonality is in service of non-identical particular interests. The commonality is in service of the non-identical common interest. There is a commonality and therefore an identity between the parties in the contract, but only relative to the thing that we talk about, only relative to the execution, the stipulation in the contract. Therefore, it's not a full and complete mediation between persons. It has a social dimension, but it is not definitory of society as a whole, and therefore not an expression of the totality of this freedom that wants to objectify itself. The contract, therefore, we have argued, with Hegel, the contract therefore has an element of arbitrariness. Only in as far as and as long as the parties to the contract are interested do we have a commonality, and there is only a binding agreement when it fits their particular interest. The commonality that we have in the contract is not aspired to, is not executed for itself, because it's important in itself, but it's a means to an end, and that means is a means to an end that is a particular end. Now, this is not a matter of how we conceive of the contract, because this limitation is not just conceptual, it's real. And we find that in this case, contracts are not just made, deals are not simply made, but they are also contested and violated. They can be contested in a court of law. It can be argued that some contracts are illegal or immoral, but they can also be violated. One of the two parties can simply decide no longer to execute the stipulation of the contract. So in crime and injustice, we see in a very real manner that the contract is not a totality of commonality, and not a real universal in that sense, but it has a limited universality, a commonality pertaining to a particular thing and a particular action, and besides that there is still the particularity of the arbitrary wills that are involved. Now that is the reason that we looked at the remark in paragraph 75, where Hegel talks about marriage and the state. The social realities of marriage and the state cannot be understood in categories of contract, and that is in opposition to Immanuel Kant, who said that marriage was still a contract pertaining to the mutual use of genitals, and the natural law tradition, Rousseau, Locke, and Hobbes, that argued that the essence of the state can be understood as a contract. Marriage and the state belong, according to Hegel, in a higher sphere of right, and that is the social right, or the Sittlichkeit, social ethics, or Sittlichkeit. Now the reason that Hegel here denies that marriage and the state are forms of contract is very important with a view to the transition to injustice and crime. Now, why can't the state be seen as based upon a contract? That is the fact that contract is itself grounded in this arbitrariness of the will. We cannot argue that the state is simply a collection of private and particular wills. The state is more than this abstract commonality, and the state is not a means for the achievement of particular ends to enhance particular interests. The state is what we find in the mutual recognition of persons that goes beyond the recognition of their ownership. Now, if the state were only connected to the recognition of ownership of external things, then we wouldn't have a real life of the state. The state wouldn't be able to maintain its existence. There are all sorts of oppositions between subjects that are sublated within the state, that are contradictions that are atoned for, that's not the proper word, are reconciled within the state. But all of these oppositions still exist in the sphere of abstract right. Now, taken upon itself, abstract right cannot maintain itself. It will always destroy itself and reach its ultimate end and negation in injustice and crime. That is what happens to the inner contradictions of a contract. Now, why is that the case? Because it is still abstract. The category of contract is dissolved because it's abstract. It has a universality that is outside of the particularity of the personalities involved. Therefore, it's permanently subjected to the force and power of the particularities that break in and that make this universality of the contract to something that is not real anymore. They are broken up. Contracts are broken. Now, the negation of the contract must make us aware of the fact that there is also a right to this particularity. This particularity, that is the opposite of the commonality of the contract, should be recognized in some fashion also, and that is the reason that we need to make the transition ultimately to the sphere of morality, where it is precisely this particular mode of our freedom that is the basis of this new form of right. Only a universality, that is truly a unity of the universal and the particular, can guarantee the existence of freedom. Only this unity of the universal and the particular can give us that. Abstract right tries to guarantee the freedom by talking about the universality of the commonality of our will, and that's not a guarantee of freedom because it leaves open the very real possibility of injustice and the breaking of contracts. Now, this universality can come to fruition when we truly understand what the will entails. The concept of the will should be better understood by looking at this new identity of universal and the particular within the singularity of persons. Now, there is a logical necessity then to come from the sphere of the contract into injustice and crime. As I said, property and contract break down in injustice and crime, but the positive result is that we see again the importance of the particularity that is involved here, and thereby we are coming into the sphere of what Hegel calls the morality. That is the sphere where the right of the singular person as a category of right is explained. Now let's go back to the summary that I wrote, and let's take a look at the next paragraph. What we have discussed so far, paragraph 71 to 75 and the introductory remarks for the second part of this video, that is the main thing, as we will see. But I don't want to just skip the intermediate paragraph, so we're going to read paragraph 76. Take some time to read it for yourself, and then we'll move on. Now, in paragraph 76, Hegel makes a distinction between the a formal contract that emphasizes the difference between the two parties. There are two acts of volition that produce and posit the commonality of the will. There is the negative moment of the disposal of a thing and the positive element of the acceptance of the thing. So we have here the element, the category as the contract, the contract as donation, Schenkungsvertrag. Now, that is a formal contract. We can also emphasize the identity here, and then we get a real exchange, ein Tauschvertrag, a swapping, the exchange. A donation, he says, is only real, not formal but real, if both parties are disowning and acquiring at the same time. Because then it is expressed what is actually happening, that even though I am disposing of this property, I still remain an owner. And even in acquiring something, I'm actually giving up property at the same time. So the elements of disowning and acquisition are logically present in both. Logically speaking, when each of the parties in the contract has the totality of these two moments within himself, then we have a real exchange. And with regard to, this is said with regard to the two volitions, the two wills involved, but it's also appearing in the notion of value. That is the topic of paragraph 77. In a real contract, the thing that I acquire is quantitatively identical to the thing that I disown. That is to say, there is an equality between these two external things that is posited. So it's not given in nature It's not a natural equality. It's a positive equality that is part of the agreement that we make. It's not based upon their objective qualities. Let's say I exchange a cow for 2 sheep. Then, of course, the equality between the two sides, the two objects that are exchanged, is based upon our own evaluation of these things. And we have an agreement about the equality of their value. Despite their external differences, two things can be equal within the exchange. That is to say, they have the same value. And most of the time that is expressed with a means, and that is, of course, money, their financial value. The identity of the two parties, that is of their volitions, is now expressed also in the commonality or the equality of the things, that is the commonality of the value. What I get is the same as what I gave up, so I remain an owner even when I disown something, but not in reality, but only as posited, as agreed upon by the arbitrary wills involved. This equality is quantitative and not qualitative. For instance, the cow that I give up must have the same value quantitatively as the 2 sheep that I acquire to have a real exchange, a real donation, a mutual donation. Since this is not the case in these external things as such, this equality of value must be posited, as we have seen. Then, paragraph 78, again, take your time to read the paragraph first and then return to our discussion here. Okay, welcome back. Paragraph 78. Within any contract there is a commonality of will. That's obvious. There is ein gemeinsamer Wille als Übereinkunft present there that's consistent with the idea of ownership, as we have seen in previous paragraphs, because this is merely the fact that wills are in a negative relation to one another, now expressed on a higher level, a positive relation to one another in the agreement. So that is the first part. The Übereinkunft, or the agreement, is the first thing that we should see. Now this is the ideal element of it, but there is also a real element through it. Now any contract must lead to a realization or effectuation. The contract as such is only a product of the imagination, a voorgesteltes, something of our inner thoughts. It is a declaration of intent, just a piece of paper that we signed. Any contract, however, demands that it is executed. This element of the execution of a contract corresponds to what we call possession. Now, I'm not talking about the thing, the property that I have control of, but the fact that I hold something in my possession, in my control. That is what we call possession. Now, that is a reality. Besitz is a reality. Besitz is something that is, in our experience, in the factuality, as opposed to the ideality of it, the ideal element of it, is in the notion of property and ownership. The ideal contents of a contract is its stipulation. Now, as such, that is only the expression of intent and not of the reality. So, the contents of a contract express intent. There is no reality involved. However, even though the intent to exchange is not the exchange itself, but as a contract, it posits this subjective contents as something that must be completed in the execution, in what Hegel calls the Leistung. It becomes an objective obligation or right. There is something in the stipulation that changes reality because it orders, it makes obligatory something that needs to be done within reality. And that is a new reality. The new reality is that I must pay something, or that I must pick up something, or that I must give up something. That is something that still needs to be done. However, the right that I have to do so, to receive, for instance, a payment, and the obligation or duty to give up a property, that is something that has changed in reality because of the signing of a contract. The difference, therefore, between property, eigentum and possession, Besitz, the ideality that lies within the recognition by others, eigentum, and possession that simply expresses a factual state. The substantial, which is the ideal here, and the merely external, that is the reality as such, returns now as the difference between the common will as agreement, what we agreed upon, and the specific element of execution that follows later. Now, we can ask a question, is there then a difference between a contract and a promise? So go on and read the long paragraph 79, and then return to the video. Okay, welcome back. Paragraph 79, a long paragraph with a long remark contained in it. From the perspective of the stipulation, that is the expression of the intent based on the agreement, so what is it exactly that we are in agreement about? The execution of the contract is a mere external thing. It's the same thing, but now in reality. It's merely this transition from the ideality of the text to the reality of the thing performed or done. The stipulation within the contract, when and how the exchange will take place, for instance, is the act in which I effectively give up a property. When you read the contract, and there you have the stipulation, and there you have that I need to give up my house or whatever, give up the cow, must bring it to a certain place where it can be transferred into the property of someone else. All of that, that has already occurred legally in the stipulation that I sign. In that act it has already become the property of someone else. He has now a claim or a right to that same thing. I am under obligation now to proceed to the execution of our agreement. Now this looks a lot like a promise. Also in a promise we have this future reality, this effectuation in the future. We have a stipulation, the thing that I promise to someone else. So in a promise we find something like a contract. Can a promise be the same as a contract? Now in a promise, however, the stipulation, that is the effective reality of the promise, is that what I want to give up, do or perform is something in the future, as a mere subjective determination of my will, as a mere subjective determination of my will. If I promise something, there is no objectivation of my will. There is also not someone else's will involved. There might be someone that I promise it to, but his or hers agreement with the promise has no bearing on the promise itself, whereas it does have a very important bearing on the contract. There can only be a contract if two wills are in agreement and both have objectified that. In the promise, that is not the case. With any promise, I'm still able to change my mind. The stipulation within the contract is, however, the reality of my act of will. Something really changed by signing the contract or making the deal verbally. I may or may not change my mind after signing it, but that will have no effect on the objective existence of my decision as expressed in the contract that everyone can see. So when my particular will acts against the contract, there is injustice. When my particular will changes my promise, I retract my promise, there is no injustice. There is no injustice. There might be something else, but that belongs to the sphere of morality and not the sphere of law. That's a matter of being untrustworthy in my social relations, etc., etc. Now, if there is something like an agreement, if the other party promises something back to me, so I promise to give you a cow and you promise to give me 2 sheep, in actual fact, what we have there is not 2 promises, but we have a contract. So you might think that if you promise something and someone else promises something, that is all just dependent upon my subjective will in the future, but in actual fact, when you have agreed upon an execution, content, you are in agreement about what should happen, you might use the language of promise, but in actual fact you are making a contract. Okay. Because something really changed. And why does something really change? Because the two wills are in agreement. There is a commonality of will that is objectified into these two promises that go together. The one is dependent upon the other. We talked about that before. This condition of this mutual conditionality of the contract. That is then also the case when we have a promise. Now, the previous thing, that is this possibility of changing my mind after signing it. That is not the case with a promise, because then I take it upon myself to do something in the future, albeit expressed to someone else who has an interest in it, in a decision that remains subject to the continuation of my will. If I don't will the same tomorrow, then my promise now is void. Here the arbitrary will is without bounds. It has no binding. My promise is not binding. The will of the other is not involved. A promise has no reciprocity. But if it does, it is a contract. If I promise X to you and you promise in return Y to me, and there is this element of mutual conditionality, I will execute my promise X only if you execute your promise Y to me, and vice versa. Then we actually have an agreement to have a contract. And we might then wish to go on and make it a real contract. Okay, take a look at paragraph 80 and then come back to me. Welcome back. We are going to talk about the real distinctions within the concept of contract very briefly. Within the nature of a contract that are specific, there are specific distinctions, as we have encountered before, between formal and real contracts. A formal contract, whenever there is an exchange, when someone gives something to another. Real contract, when we have a mutual equality, I'm getting something back. So the totality of the arbitrary wills involved is expressed in the commonality. This exchange means I get something back for what I give. Then it's a real contract. Property and possession, Eigentum und Besitz, as distinct from another, so the substance and the appearance. Use, of course, as an intermediate category that is not completely property but based upon property, but it's a right that I can give to someone else, remaining my property but giving up my possession. And then value, that's the idea that there is a positive equality between the two things that are exchanged. Now, all of these distinctions that we discussed before can be used to come to a list of varieties of the contract. So, contracts of donation, donating something without further qualification, that's proper donation. Lending out, donating a part of a thing, donating a limited use of a thing, or giving a loan where there is something in return, so it's a real contract because I pay interest. You can have a donation of a service, a contract to keep a property safe, whatever. All of these are contracts of donation, so we have elements of the equality of the things involved, value, etc. Now, contracts of exchange, there we have the full use of the concept of a real contract, exchanging one thing for another, swapping, buying something, renting something out, and of course an employment contract. My acts of production or service are exchanged for money for a specific and limited time, etc. That it also brings me into a relationship between employer and employee is something that you cannot express in abstract right. So the whole idea of paid labor and wages and the rightfulness of that and the economic aspects of that, you cannot discuss that in terms of abstract right. So when you live in a society where employment is only discussed in terms of abstract right, you might get this horrific labor situations as in the Industrial Revolution in England and all of that, and child labor. So we shouldn't deal with employment, with labor, in terms of abstract right, and Hegel acknowledges that in other places. So we move on. To me, a very difficult passage to read is the C section, Verpfändung, contract of mortgage, I've called it here. One thing out of all of that, my property can become a collateral, for instance, when I have a loan, the payment of which is guaranteed by the conditional transference of property rights to the lender. Well, let's just skip all of that. It's obvious that also that is a form of contract. Okay, we come to paragraph 81. Take your time to read that paragraph and then come back to the video. Welcome back. Paragraph 81. We're going to talk about the transition to injustice. In the relationship between immediate personalities, or personalities just as they appear externally, there is this commonality of will, but there is also this particularity of the will. The contract is in itself something that is coincidental, it's not necessary, it's just something that might happen, it's arbitrary. The persons express themselves as arbitrary, their agreement is arbitrary, the thing discussed is arbitrary. So even though it's quite interesting to see what elements of intersubjectivity are involved in a contract, the contract as such is riddled with arbitrariness. So what can we say about that? Although a common will is expressed in the contract, the parties within the contract remain particular. I think in English you should say the parties to a contract. Let's do it like that, not parties within the contract. As particular individuals, they remain characterized by arbitrariness, and it's possible that these factual individual wills will differ from the common will that is expressed in the contract. I sign a contract to teach you today, and then tomorrow I don't feel like it anymore, and I simply break the contract. A person may decide to oppose his own previous decision. That's arbitrary will. I want this, I don't want it anymore, I want something else. I can do that with my objectified will just as much as with any external object. A person may decide to oppose his own previous decision and act differently than was stipulated. You pay the money but don't get the thing. The owner has changed his mind. Insofar as the contract is the objective reality of right, this contradiction of the contract by a particular will is not right. So it's this subjectivity cannot be allowed, so we have to call it injustice. So what does this mean? It means that in the contract, the contradiction between arbitrary will, that is, the power to assert and withdraw my will at random, for whatever reason I want to give myself, and this commonality of the will in the contract, which is a mere posited identity of the will, which is a relative universal, because it's only a commonality and not a true universal. It's an agreed upon universal, which is impossible in itself. It's a contradiction in itself. A universal is a necessary commonality, and this is an arbitrary commonality. Now all of this, the contradiction is not yet reconciled in the contract. This particularity remains outside of the contract and can disturb the contract. That only demonstrates that the contract is not yet the expression of the true universality of the will. It's not the full embodiment of the freedom that wants to give itself objectivity. As I said before, a contract is deeply determined by our social relationships, but does not yet define society. We have to find now the rationality of the particularity of the will that remains outside of the agreement in the contract, the commonality that is there in the contract. And that we will do when we start to discuss paragraph 82, Injustice, the third chapter of the Philosophy of Right. And we hope to get there by the end of next week. Thanks for listening, and have a good week, and enjoy reading Hegel, and goodbye for now.